As you can see from the title of my presentation, which is going to be brief, it's an insider's perspective as a forensic practitioner, as a former prosecutor, as an attorney, as someone that was trained initially, was going to be a psychiatrist, so I took the pre-med courses before I went to the dark side and pursued forensic science and law. So what I'm saying is my perspective and my perspective only. Our duty as forensic experts is to render an unbiased opinion on matters within our subject matter expertise. This duty overrides any obligation to the party or entity that hires us or pays us. And ideally, we should always be uninterested and unaffected by whatever decision we ultimately arrive at from an analysis of the evidence. Unfortunately, we know that as humans, we are all susceptible to biasing influences and motivational factors that may cause us to favor a particular outcome and unconsciously act in a manner that is not impartial and not objective. Moreover, as forensic experts, all of us have faced subtle and sometimes not so subtle pressures from an attorney, client, or some other interested party to reach a particular outcome, or for that matter, to express an opinion with a greater level of certainty than that which we initially reported or which we express comfort with. That's simply the current landscape of the adversarial system we find ourselves working in. Some of us may have a little trouble avoiding biasing influences and resisting pressures from the parties that hire or employ us, while others may not be as resistant. Hence, the legitimate concern about cognitive and motivational bias. It's not hard for me to say as a practical matter that we as experts are expendable tools that lawyers need and hope to use to achieve a favorable outcome for their client and case. Doesn't matter if it's a criminal case or a civil case. That's a fact of life. But in the administration of justice, civil or criminal, the impact of an error in judgment is very different when it comes to mistakes by lawyers or experts. Lawyers walk away from their mistakes. Experts have theirs published, and they're brought up against them every time they testify. So we as experts clearly want to do everything to minimize our chances of making mistakes in our casework, as well as avoiding bias or any other behavior that could provide a means for an opposing attorney to impeach our credibility or integrity on cross-examination. So, that being said, I don't see why we shouldn't do everything we can to avoid even the appearance of impropriety or bias, since doing so will ultimately serve not just our best interest, but the interest of justice. It's a win-win situation. We, as forensic scientists, as a group, need to reduce the perception that forensic experts are hired guns seeking to interpret evidence in a manner that supports the side who is paying for their services, rather than impartial experts seeking to discover the truth in an objective manner. So frankly, from my perspective, I see no reason, and as a handwriting expert, I've used bias control measures in my practice as a routine standard. I don't see why anybody should object to exemplar lineups, blind testing procedures. We do them when we take proficiency tests. We do them when we take tests for certification. There's no reason for us not to do it in our casework. It will reduce the stress and pressure of having other people try to push us towards reaching a particular opinion. We can honestly say, look, I analyzed the evidence. This is what my conclusions were. Take it or leave it is the preferred option. Now, most of you are critical observers, so you can see that it's readily apparent that I have an appreciation for food. And with that, I'd like to leave you with some food for thought. You've heard a lot of mention about the need to improve the accuracy and integrity and impartiality of decision-making in forensic science and the nature of the testimony that comes in, be it through a report or through testimony in court. That objective should not be limited to criminal justice, nor should it be limited to prosecution source experts. It should be across the board. If the interest is in having science that comes into a courtroom be independent, impartial, and accurate, it should apply to everybody. So, I think that research needs to be done to develop practical measures that will apply not just to prosecution experts, but to defense experts in criminal cases and to experts for plaintiffs and defendants in civil cases. Whether that's going to be done through blind testing procedures, the use of case managers in institutional settings, maybe court-appointed subject matter experts as case managers in civil settings, whatever the case may be, the objective is to have testifying experts testifying based upon independent, accurate, and objective analysis of evidence. If a lawyer wants to get an expert as a consulting expert to raise issues as to procedures or other factors, they'd be free to do that. But the ultimate objective, both with respect to the NAS report and anybody else that's concerned about the interest of justice, is to make sure that evidence from forensic science providers that comes into a court of law, be it criminal case or a civil case, is based upon accurate, independent, and objective analysis of evidence. And I encourage everybody to think along those lines and to encourage NIST and the National Commission of Forensic Science to explore areas that are not limited simply to prosecution experts. There is the interest of justice not only require that we be concerned about wrongful convictions, and rightfully so, but wrongful acquittals of the incredibly guilty is also a factor that we should consider. And with that, I say thank you.